The Johannesburg High Court has dismissed an application that would have allowed retired judges facing complaints of misconduct not to be held accountable. The case had been brought by retired Supreme Court of Appeal Justice Willie Seriti and retired Free State High Court Judge President Hendrick Musi. They challenged the constitutionality of the Judicial Service Commission Act. A complaint had been laid against them, or has been, for the way they conducted the Arms Deal Commission of Inquiry. The commission, chaired by Seriti, you'll recall, exonerated most players, but its findings were set aside in 2019 by the Pretoria High Court, which said the commission had failed to comply with its mandate to investigate the claims. Let's speak to a lawyer for Open Secrets now, Luthando Vilakazi. Thank you for being with us, Ms. Vilakazi, and we'll talk about the involvement of Open Secrets in actually pushing this case forward. But firstly, it's interesting because both of these judges are retired. So they said the Constitution effectively said judges hold office until they are discharged. But the judge in the matter validates seemingly your view that judges are judges for life. Just tell us a bit more about the legal argument.
Hi, Francis. Thanks so much for having me. Yes, so the judgment delivered by Deputy Judge President Sutherland said that one of the arguments that Judges Seriti and Musi had made was that they are not judges for life, but the fact that they continue to, receive their pensions through the public purse, and in particular, Judge Sutherland said that essentially, because of the nature in which judges who have retired continue to be regulated by legislation, including the Judicial Remuneration Act and the Judicial Services Commission Act, it is plainly wrong in law to say that it's unconstitutional for judges post their active service to be held under the framework that is existing in the legislation.
All right, so if a judge is a judge for life, then they should be held to account for life, or be open to being held accountable at any time. That is the crux of the argument.
Yes, and the idea there is that it should not be a loophole for judges to no longer be held to account for any misconduct during their service by simply initiating the retirement process, and then their status as former judges now protects them from being accountable for things that they should be accountable for, regardless of whether they are in active service or not.
The feeling of many, after revelations of arms deal corruption, was that the Seriti Commission was a whitewash. What are you claiming the judges should have done fundamentally differently?
So, we have the judgment that set aside the Commission's report, and one of the findings in that case was that significant evidence was ignored by Justice Seriti and Musi. Many persons who were able to give testimony were not communicated with. They did not see requests from the Commission to give evidence. And because of this ongoing seeming lack or sort of fine-tooth combing of the investigation, certain persons who were going to give testimony protested. Many members of the Commission who were acting in other capacities also protested and resigned from continuing to be a part of that Commission. And, as you said, we have former SCA judges presiding over this case, and it seems deeply, deeply disturbing that they could overlook so much of the evidence that was available to them.
And after that judgment that set aside the Commission, Open Secrets was one of the NGOs that then laid a complaint. Just tell me, why is this so important for you, for your NGO? Because it could be said that it'll make the justice system look bad if this is really thrashed out. But you're saying if they're not held to account, that'll really undermine trust in the judiciary.
Absolutely. And it's also about making sure that the institutions that we have that do hold accountable perpetrators of misconduct, wrongdoing, criminal conduct are actually able to function. One of the things that we asked for in the complaint was for any criminal conduct to also be pursued by the NPA should the tribunal find that there is a chance that they may have been acting in a criminal capacity. But over and above that, why? I mean, the arms deal happened, how many decades ago? And, one might think it's too long ago, not worth the time. We have other crises to be turning our attention to. But if we continue to let that kind of attitude prevail, the bad guys get away with all of it. And we cannot right now, in the state of our democracy, the state of our economic situation, allow that kind of attitude to have any kind of credence. Where we can fight for justice, we have to do so.
Should other judges in finality be concerned? I was thinking about the public protector who's facing Parliament, and she recently said, look, she's being grilled, but the judgments of judges are overturned all the time. And I thought that's quite interesting. That does often happen. But it seems to me this isn't about a single finding or the logic of a case, but expressly about what they did or didn't do in a very important capacity.
Yes, absolutely. And it could be a sign of gross misconduct in that respect. And, let's remember also that the judges who delivered the judgment on Friday are also sort of speaking to what would happen to them if they were ever found to be guilty of misconduct or to have complaints laid against them. This is something that clearly is a message from the judiciary that they expect to be accountable to their peers. And that is something that can only restore trust in the judiciary or to bolster that trust and have it be known that they are an impartial body that is capable of being critical of itself.
Good point to end on. Thank you for that, lawyer for Open Secrets, Luthando Vilakazi.